Hello guys, welcome to our channel Legal Nexus. Today we are going to discuss about joint tort feasor. A tort feasor means in general sense a person who commit tort. A joint tort feasor means a tort is committed by several persons. Such person be either joint tort feasor or independent tort feasor. If all the persons are liable for the same tort, then they are deemed to be joint tort feasor. Independent tort feasors means if several persons acting independently and do not occur a single damage, the independent tort produced are called feasors. Essentials of joint tort feasors. They must commit tort in furtherance of common design. There must be concerned action among them. Illustration. Two drivers X and Y with object of getting in front of car driven by Z drive their cars in a rash and negligent manner that both their cars coiled against Z's car and damage is caused without concerned action. Between Z and Y, they are independent tortfeasors. There are three circumstances in which joint tortfeasors arise: agency, vicarious liability, joint or common action. The first circumstance, agency. If A is an agent of B to act on behalf of then, the tort committed by the agent holds both principal A and agent B liable. Vicarious liability. If a servant committed tort in course of employment of his master, the law imposes vicarious liability or master on the employer, both the master and servant deemed to be joint tortfeasors. Joint or common action. If any joint act is done by several persons in pursuance of a concerned purpose, all those who jointly committed the tort are liable for it, irrespective of their share of each person in tort. Nature of tortfeasors liability. The tortfeasors are jointly and severally liable. A release of one of the several tortfeasors, release of all others. If a judgment obtained against one of the tortfeasor and if the whole amount of damage is obtained from him, then the other joint feasors cannot be sued. Rules regarding the liability of tortfeasor. There are two rules regarding the liability of tortfeasors. Rules in Burnsmith's case. Rules in Meriwether's case. The rule in Burnsmith's case, Burnsmith versus Harrison, H and T were responsible jointly for damage of B's piano. As B could not get any amount from T, he sued other wrongdoer H to obtain the price of the piano. It was held that the prior judgment obtained by B against T was bar to subsequent action against the other tortfeasor H. The decision was based on the principle that in interest of the state, there must be finality to litigation. A judgment obtained against any of the joint tortfeasor is deemed to be release of the other. To avoid such hardship caused to such plaintiff as in Burnsmith's case, the law was modified by the Law Reforms Act 1935. Rule of no contribution between joint tortfeasors. In Meriwether versus Nixon, this rule is based on maxim ex ubi cause non oritur actio, which means out of a turpitude or bad act, no action will arise. So, a joint tortfeasor who has satisfied the claim of the plaintiff cannot seek any contribution from other tortfeasors. Arnold versus Patterson. Two dogs belongs to two different owners attacked and injured several sheep. The owner of the sheep claimed damages from both the